Throughout this video, a number of times we've talked about what happens if we refuse to take various kinds of tests. But let's, if we can, for just a moment, go more in depth on some of these. So in recapping, for example, if you don't take tests, field sobriety tests or other tests, does that make you automatically guilty in North Carolina?
Well, absolutely not. You have a right to refuse field sobriety tests and a right to refuse the little handheld out on the side of the road with no ramifications. The question becomes what happens when you get downtown and you're put in front of the true intox machine. You're then read what we call implied consent rights, and it's a legal fiction that says by getting a license you have implied that you will consent to blow on the breath machine.
I didn't know that.
So it's called the implied consent law that basically says you got to blow or else you're going to lose your license. Now, it's not that black and white. I mean, the law is if you willfully refuse and the state proves that in an administrative hearing, you will lose your license for 1 full year.
You know, I'm already nervous just hearing you describe this. So let's say I'm nervous, I've been pulled over, I've been stopped for DWI, they take me back to the station, and let's say for one reason or another, either through lung capacity or I'm upset or whatever, I don't blow hard enough on a test. What happens?
Well, at that point, unfortunately, North Carolina doesn't have any way for the law enforcement officer to push a button that says, gee, you blew hard, but you couldn't blow hard enough. They only have, you got to blow or you refused. So what's going to happen, whether you're blowing as hard as you can or not? They're going to punch a button that says you refused a breath test. Well, that's going to kick in a nightmare. They're going to take your license that night on the spot for 30 days, just as if you'd blown a .08. So they take the pre-trial 30-day license seizure. Then at the end of 30 days, you'd get your driver's license back and wait for trial. Okay, so because you still have a criminal trial ahead of you.
Right.
But unrelated to that, you now have violated the implied consent law. So once these affidavits that you have refused get down to Raleigh, Raleigh's going to generate a letter to you saying, we have an affidavit saying you've refused to take a breathalyzer, turn in your license within 10 days.
Even though you took it, but you just didn't blow hard enough.
Even though. And this is critical, and this is what I want you out there that may see this. If you have been charged with refusing to take a breath test, there is a window of time. You have 10 days from when you get a letter from the Division of Motor Vehicles to request a hearing. And if you don't do it within that 10 days, you have lost your administrative right to appeal that. So that's probably the most pressing thing that people need to hear. If you have been charged with refusing a breath test, don't sit around and get your case continued in court because you're saving up some money to go see a lawyer and see a lawyer in 60 days, because if you do, your rights are gone.
Do the police, once you're back at the station and they're doing these things we're talking about, do they have to, in writing or orally, tell you about the ramifications of what happens if you don't take a particular test?
Yes, that's called your implied consent rights, and those are all laid out in North Carolina General Statute 20-16.2. And they've got to advise you that if you refuse the test, you're going to lose your license for a year. And that gets into a whole other area of the law, because we have what we call administrative law on whether or not that is a willful refusal, whether or not they followed the right procedures. If the court were to determine that they had no probable cause to arrest you because of a 20-minute violation out on the side of the road,
right, and
the district court rules that they had no probable cause to arrest, well, then you can carry through collateral estoppel, you can carry that district court order over into the Division of Motor Vehicles and get what's called estoppel and keep your license. So the two areas overlap tremendously, and you got to be familiar with both. But the refusal takes place out at the Division of Motor Vehicles, a hearing out there. The trial takes place in a criminal courtroom. But you've got to be prepared to fight both.
Well, as we get ready for trial, we want to backtrack a little bit on one topic, and that's talking about those motions to suppress, and we'll do that in this next segment.